In the United States, the rule of law is not merely a moral slogan or a rhetorical flourish used in political speeches. It is a structural principle that underpins the entire constitutional order. At its core, the rule of law means that every person, citizens, government officials, and even the president, is accountable under the law. Laws must be applied fairly, legal procedures must be transparent, and courts must operate independently from political pressure. That system functions only if the public accepts one crucial premise, that courts have the legitimate authority to resolve disputes, even when their decisions are unpopular or politically inconvenient. And this is where the current confrontation becomes significant. In the series of legal battles surrounding Donald Trump, the central question is no longer simply whether he will win or lose a particular case. The deeper question is whether the judicial system itself can maintain its authority when it becomes the direct target of political attack. Under normal circumstances, when someone disagrees with a judge, there is a clear path forward. The legal system provides mechanisms for appeal. Lawyers challenge rulings through legal briefs. They argue about precedent, statutory interpretation, and constitutional authority. But when disputes shift from legal argument to political confrontation, when judges are portrayed not as arbiters of law but as partisan adversaries, the damage extends beyond any individual case. What begins to erode is public confidence in the courts themselves, and that confidence is essential. The framers of the U.S. Constitution designed the American government around a system of separated powers. Congress writes the laws, the executive branch enforces them, and the judiciary interprets them. Each branch checks the others. But the system assumes something important, that no branch can simply declare itself beyond legal restraint. The presidency, despite its immense power, was never intended to operate as an unchecked authority. It was designed to function within a network of constitutional limits. This is why the legal controversies involving Trump have increasingly centered on a specific question: how far presidential immunity extends. In July 2024, the United States Supreme Court addressed that question in the case Trump versus United States. The court concluded that a president has absolute immunity for core constitutional powers, presumptive immunity for official acts, and no immunity for unofficial acts. That decision rejected the argument that a former president could never be prosecuted, but it also established significant protections for actions taken within the scope of presidential duties, and that is where the legal complexity begins. Because once the court acknowledges broad immunity for official conduct, the next question becomes unavoidable. Who determines whether an action qualifies as an official act? That question may sound technical, but it carries enormous implications. If the category of official acts becomes expansive enough, it could shield a wide range of behavior from criminal liability. Actions that might otherwise be scrutinized under ordinary legal standards could instead be protected under the umbrella of executive authority. The Department of Justice warned about precisely this risk during the litigation. Government lawyers argued that an overly broad immunity doctrine could create a dangerous precedent, one that places former presidents in a position effectively beyond the reach of criminal law for certain conduct. This concern does not arise from partisan disagreement. It arises from constitutional design. A democracy must protect public officials from frivolous or politically motivated prosecutions, but that protection cannot be so extensive that it eliminates accountability altogether. The challenge is maintaining the balance. Too little protection, and the presidency becomes vulnerable to endless legal harassment. Too much protection, and the presidency becomes insulated from the very laws it is supposed to uphold. And once that balance shifts too far toward immunity, the principle that no one is above the law begins to weaken. Another troubling dimension of the current moment is the growing tendency to transform legal disputes into political campaigns against the judiciary itself. The American judicial system has historically survived intense political disagreements because of a widely shared understanding. Judges may be criticized, their decisions may be challenged, but their authority must ultimately be respected. When that distinction collapses, when criticism becomes delegitimization, the consequences extend beyond any particular ruling. Federal courts have already warned about rising threats against judges. Security concerns for members of the judiciary have increased significantly in recent years. Judges have required protection from U.S. Marshals simply for carrying out their duties. That environment poses a profound challenge to judicial independence. because courts depend on more than written statutes. They depend on legitimacy. A court's authority is not enforced solely by police power. It is sustained by the public's belief that legal decisions deserve compliance, even when those decisions are controversial. Once large segments of the public begin to view the courts as merely political actors, that legitimacy weakens. And when legitimacy weakens, the rule of law itself becomes fragile. It is important to understand that the collapse of the rule of law does not typically happen through dramatic or sudden events. Courts do not suddenly disappear. Judges continue wearing their robes. Legal filings are still submitted. Hearings are still scheduled. From the outside, the institutional structure appears unchanged. But beneath that structure, something subtle begins to shift. Political actors start treating legal constraints as obstacles rather than obligations. Court rulings are framed as partisan attacks rather than legal judgments. Compliance with the law becomes conditional, accepted when convenient, rejected when unfavorable. Over time, the legal system becomes less about binding rules and more about political negotiation. That is the quiet erosion of the rule of law. Donald Trump occupies a unique position within this dynamic. He is simultaneously a former president, a current political candidate, and a defendant in multiple legal proceedings. That combination creates an unusual and volatile intersection between law and politics. Trump's public rhetoric often frames legal investigations as politically motivated. For supporters, that argument resonates as a defense against perceived institutional bias. For critics, it appears as an attempt to undermine judicial authority. Regardless of which interpretation one favors, the broader institutional consequences remain the same. The more the courts are drawn into partisan conflict, the more their legitimacy risks becoming a matter of political alignment rather than legal reasoning, and that transformation carries long-term consequences because precedents do not only shape legal doctrine, they shape political expectations. If a political leader successfully establishes the idea that adverse court rulings can simply be dismissed as illegitimate, future leaders may adopt the same strategy. The danger is not only the precedent itself, but the normalization of that precedent. Future presidents might push the boundaries even further, perhaps more quietly, perhaps more strategically. But once the principle of equal accountability begins to weaken, restoring it becomes extraordinarily difficult. The true question raised by this confrontation is therefore not whether Trump will prevail in a specific legal battle. The real question is whether the American system can maintain the principle that legal authority ultimately supersedes political power. If courts retain the ability to adjudicate disputes independently, free from intimidation, free from partisan capture, then the constitutional system remains resilient. But if judicial authority becomes contingent on political approval, the consequences extend far beyond one presidency. They reshape the entire structure of democratic governance. Because in a functioning republic, the law is supposed to restrain power. If power begins to restrain the law instead, the balance envisioned by the Constitution begins to reverse. And when that reversal happens gradually, through legal arguments, political messaging, and public fatigue, it can take years before society recognizes the magnitude of the change. By the time the shift becomes obvious, the institutional habits that once protected the rule of law may already be weakened. That is why the current confrontation between Trump and the American courts matters so deeply. It is not simply a dispute over legal immunity or prosecutorial authority or judicial procedure. It is a stress test for the constitutional system itself. The question is whether the United States can still uphold the principle that the law binds the powerful just as firmly as it binds everyone else. If that principle survives, the American legal system will endure this moment. If it erodes, the consequences will not arrive in a dramatic collapse. They will arrive slowly through normalization, through precedent, and through the quiet adjustment of expectations about what the law can and cannot do. And that is how the rule of law fades in modern democracies, not with a single decision, but with a series of decisions that gradually redefine the limits of accountability. The outcome of this moment will therefore shape not only the legal fate of one individual, but the institutional future of the American Republic itself.